Okay, that's okay. That's a good.
Yeah, that can be initiated, na? That can
Yeah, not against the corporate debtor, but against the corporate guarantor. Since corporate,
Yes, corporate
debtor is not
guarantor.
a company, corporate person.
Corporate person, yeah.
Sir, a question I think in group we are discussing the financial institution that defined some institutions, Reserve Bank and 45A and Companies Act, whatever they notified. Any other institution notified by the government, whether how many institutions notified by the government as a financial institution? Do we have any records, sir?
Sorry, sir, but can you repeat the question?
The question is, sir, the financial institution definition.
Yeah.
One is
list can be you can say traced, but right now I do not have that list.
Yeah. Okay.
Yeah. So there are around 7 questions are on the High Court case law. So what we will do, we will first go through the High Court case law in one go, and then we will discuss the question. Is it the better approach? Is my screen is visible to all?
Yes, sir. Yes, sir.
So what we will do first we will discuss the High Court case law in one go. We will discuss about some brief of the High Court case law. Then we will come to the question answer, MCQ.
Yeah.
So there are 9 case laws.
Only brief facts.
Yeah, only brief facts, so that we can go through all the MCQs.
Yes.
So there are 9 case laws in the High Court case law list. One is Sri Metallic Limited versus Union of India. So in this case,
natural justice.
Natural justice.
Yeah. So in this case, a writ petition was filed by the Sri Metallic Limited because he got the section notice. His application against Sri Metallic was admitted by the NCLT, and Sri Metallic was not given the opportunity of being heard by the NCLT. So Sri Metallic was not happy with the process followed by the NCLT. So he filed a application against writ petition against NCLT. In this case, second is Kesman and Wakefield India Private Limited. Basically, this is against the registered valuer rules. There was one notification of MCA in which it said that if any company is a subsidiary or a joint venture of any company, then that company cannot be a registered valuer. So because there are some professional values that has to be taken care by the bodies that regulate that profession. So that notification was challenged in this case.
Hello.
Sir, what happened?
Can you allow me 2 minutes? Actually, I
Okay, okay,
need a
sir.
phone call, please.
Yeah, yeah, no problem.
Sir, have the presentation has been shared in the group? Sorry, I was not knowing. I am not able to check. Hello, William Rajuji.
Sir,
Is there a presentation shared in the group? Already
this
shared in
one,
the-
no.
This one, no. Okay. So we have no case law, no? Case list.
No, what they shared is,
Case studies liquidation last PPT.
नहीं नहीं वो नहीं केस स्टडी लिक्विडेशन में रेगुलर केस स्टडी ये नहीं है.
Okay, okay.
Tripathi Saab is there? Hello?
I think Mr. Tripathi is present.
Tripathi ji?
There is no one named Tripathi.
No, no, he is in the group, is answering some questions.
Okay.
She is Tripti, sir. Tripti.
Yes, yes, Tripti Agarwal. Sorry. Is there?
So, thanks, friends, for allowing me some time. So, next case law is Univalue Project Private Limited. Basically, in this case, what was the issue? Issue was that there was a notification was issued by the NCLT, the principal bench. It said that for all the cases, IBC cases again under Section 7, the proof of default from the record of information utility IU has to be submitted. If there is no default record has been attached with the application from the IU, then the application will not be taken or accepted. And this was for the new application. And if there is any application already submitted, then in the next hearing, the default record from the IU has to be submitted. So this was this was challenged in this case with petition.
Then what is the decision, sir, in this?
So that notification has been struck down because it says that if if the IU record is not available, then it's not the basically fair to say that the application will not be processed. If there is record, because if bank provide the loan or any NBFC or anything, any company, any bank provide the loan, then there is a sanction letter, then there are other documents available. The application can be filed based on those documents as well. And next case is Tata Steel BSL Limited versus Union of India. In this case, what happened? Basically, Tata Steel has acquired the Bhushan Steel Limited, and the Tata Steel become Tata Steel BSL Limited. So there was some inquiry was pending against the Bhushan Steel in different agencies like ED, CBI. So they approached
No, sir, but by SFIO.
SFIO.
Right.
So they approached the Tata Steel new management. So they said that under the there is a clean slate principle, and you cannot ask any. You cannot. These inquiry can be not be pursued against the new management.
Your previous offenses, they are not
Yeah, for
responsible
the previous
for the
offenses
previous.
and against the new management. Yes.
Even corporate debtor also, no, sir?
Yeah.
Even for corporate debtor also, once a resolution plan is approved,
Yes.
even
Yes.
prior offenses, corporate debtor also cannot be prosecuted, no?
Yes.
Yes,
Hello,
sir.
sir. In Tata Steel's case, Tata Steel will not be liable for
Yes,
the
Tata Steel will
yes,
not be
yes.
liable.
for the
Will not be.
misconduct of BSL, Bhushan Steel.
Bhushan
Yes,
Steel
yes.
Management, yes.
Yeah,
Yes. Next is Jotun India Private Limited. Basically, in this case, if I can brief you in 2 lines about this case, is that one petition was filed in the in the High Court under the one winding up petition was already initiated against a company by the operational creditor, and that was under hearing. After the enactment of the IBC, the section 10 application was filed by the corporate debtor. So what the company matter judge of the High Court said did this, he stayed the proceeding under section 10 of the IBC. He issued order, written non-speaking order, and he stayed the proceeding of the IBC under section 10. So when the matter was referred to the you can say the different bench, then the decision of the High Court was that the company court does not have any jurisdiction to stay on the proceeding of the IBC. So this was the decision. Next is
Sir, one thing, what is the meaning of company code here? The case is pending in the High Court, but what is the company code? The NCLT or other court? What's the meaning of company code here?
company court means you can say the bench who was taking care of the matter.
Bench of High Court. There is
Yes,
a,
yes.
there is a
Bench of
single
High
bench, three judge bench in the High Court.
It was a
Which
single
bench?
judge bench who was single
No, in which court?
judge
That
who was,
is in
who
High
was
Court or
taking care
lower
of
court or?
that matter. High Court. When the single bench of the judge was looking at this matter, when the matter goes to the NCLT, he stayed the proceeding under section 10 of the IPC. When the matter was referred to the bigger bench, then this was the decision of the bigger bench of the High Court.
Okay.
Yeah.
So NCLT is a company code here, no?
NCLT is the equivalent to the High Court, we can say NCLT. It's not
No,
the
High Court is telling that the company code should not have the power of excessive power. But the company code, what's the, here company code means the NCLT.
No, sir,
That's
High
good.
Court,
That
sir, High Court,
Uh-huh.
they have a benches and a
Yeah,
company court. That was subsequently with the with the establishment of NCLT and NCLAD, that company bench was abolished now. It is not there in the High Courts.
The company bench in the High Court.
High
Yes.
Court, company bench means High Court may, their people will see different matters.
Yeah,
So
yeah.
based on the expertise, they have a
Uh-huh.
company bench is there.
Okay.
That bench was abolished now because all the company
Acha,
matters
acha.
will be
All the
dealt by
matter will be,
NCLT.
the NCLT will look after
Yeah.
that matter. Okay, okay.
Even Supreme Court suggested means as an advisory to the High Courts, don't interpret the IBC also. That is the reason why they stopped. Now cases are not coming from High Courts. Is it correct, sir?
yes, sir. Yes.
Yeah. Right.
So next case is Dr. Vidyasagar versus IBBI. Basically, there was Dr. Vidyasagar has applied with the IBBI to register as an insolvency professional. One FIR has been registered against Dr. Vidyasagar, and the hearing matter was under consideration of some different trial court. So IBBI has not accepted his application to register as a IP. So he filed a writ petition and he challenged the decision of the IBBI. That since the matter is under process, so they say that once your application, the decision come of that court, then after that decision you can approach us if IBBI did not register you after that decision of that concerned court. Then the deputy director ED versus Axis Bank and others. So there are, in this case, there are many.
Hello, sir. In the
Yeah.
previous, in the Vidyasagar Garg, I have a question.
Yes.
The misconduct of the IP, that is the matter of the IBBI or
No.
NCLT? That disciplinary action will take the NCLT or IBBI?
IBBI can also take, na, both has the power.
No, who will take the action? IBBI or IPA or NCLT?
When you apply for the IBBI,
He is a member of IPA and NCLT is the court and the IBBI is a pedant body. Who will look after the disciplinary action? Who will take the
IBBA,
disciplinary-
sir. NCLT has
IBBI.
no role. NCLT
Huh?
has no role.
NCLT has no role.
Yes.
IBBI will take the disciplinary action. Okay, thank you.
Sir, is it correct?
This Raju, na? William Raju. Hyderabad.
the next is the Director of Enforcement versus Axis Bank and others. So in this case, there are many banks involved. The application of many banks like Axis Bank, PNB has been clubbed, and there was one hearing for those. All the application of different bank has been clubbed, and there was the one hearing for those cases in one go. So in all the cases, the ED was involved. So decision was that there are many cases. So issue is whether the PMLA, Prevention of Money Laundering, IBC, Surface I, there are the contradictory or the who override each other. Like can PMLA override the provision of IBC and Surface I? And if like there is any property which has not been you can say earned or purchased from the proceed of crime, then who has the right over that property? That bank from whom the corporate debtor or the person has taken a loan against the security of that property, or the ED who has attached that property. So in this case, the High Court decision was that if there is a property which is not generated or which is not purchased from the proceed of crime, because the core of the PMLA is the proceed of the crime offense. So if the High Court decision was that if there is any property which is not purchased from the proceed of crime, then and against that property any loan has been taken, then the bank, the ED will took the back sheet, and bank can take over that property. And the second decision was that the provision of PMLA will override the provision of IBC, Surface I, RDDB, or any other act.
No, sir.
Under section 234 of the IBC will override any other law.
No, sir.
And in case of PMLA and IBC case are that two cases. The two cases will go side by side.
Side by side, but if there is any contradiction, the
IBC will prevail.
No, sir.
IBC will prevail over PMLA. If the proceed is not from the black money, that will IBC will prevail.
Yeah,
if it is from the ill-gotten money, so the PMLA will override.
Yes. If there is a proceed of crime, then PMLA will override.
Yeah.
C. Venkat Shivkumar versus IBBI. So in this case, different basically ruling of IBBI challenged. Like IBBI charge percentage, the fees of percentage of revenue, and different other ruling of IBBI was challenged. Next is Venus Recruiter Private Limited versus Union of India.
That is, sir, Venkat Shivkumar, that is a fee, annual fee, na?
Yeah, annual fee and that 0.25% of that.
Yeah, that was challenged. Okay.
Yes. Venus Recruiter Private Limited versus Union of India. In this case, basically after the completion of CIRP, RP.
Hello, sir.
Yes.
Can you repeat the previous case, Venkat Shivakumar case?
Basically, Venkat Shivkumar was the practitioner, CA and insolvency professional. So there was some ruling about the annual fees.
Okay, okay, okay. Okay, I got it. Okay, sir.
Yeah. So he
And succession fees is claimed actually. Success fees is claimed.
no, sir. There was no success fees in IBBI regulation.
No, that is only in this year.
So basically, there was the fees based on the revenue of the insolvency professional. He challenged. me.
Annual fee
Annual
paid to the
fees.
IBBI.
Yeah.
Okay.
He challenged
Rupees
that.
10,000.
Venus accrued.
Rupees 10,000 per annum.
No. Percentage of fee he collected over the year.
That is 0.5%, no?
Whatever it may be, that was challenged. Why?
Now,
he
what
should
is the
share with-
percentage? That is 0.5.
Yeah,
of the
that
revenue?
also he questioned that.
So
Question actually AFA then question actually AFA then the question Venkata Sivakumar question AFA then question.
there are many regulations which has been challenged. Like IBBI does not provide any service to the IP. So
Okay.
yeah. So how can he charge the fees based on percentage?
Okay.
So he said that there is excessive delegation by the IBBI. So just we are discussing some brief part of the cases.
Yeah. We got
Okay.
the
Why? I catch it.
Venus Recruiter Private Limited versus Union of India. In this case, basically after the completion of the CIRP, the RP came to know about the PUFP transaction. So he reported those transactions. So there was a decision that after the completion of CIRP, RP cannot report any transaction by taking a stand like he is a former RP and he cannot file any case against those matter. RP cannot wear the hat of the former RP and can say that now he has come to know about some fraudulent transaction. So this was the case. So now we will go through the MCQs. We have just taken a view of the High Court cases, fact of the High Court cases. So MCQ is visible.
Yes, sir.
So in which of the following case High Court observed and held that NCLT acting under the provision of the Act while disposing any proceeding before it is not bound by the process laid down under the Code of Civil Procedure 1908. Sri Metallic, Cushman and Wakefield, DD, Deputy Director of ED, or Akshay Jhunjhunwala and others.
Akshay Jhunjhunwala.
Basically, they can provide the option of different case laws which are not part
That
of
is not our syllabus.
just to confuse the participant. You can say examine student or the person. So which one is the answer? Which is the answer? There are 4 options.
Sri Metallic, sir.
Sri Metallic, yes.
But that is a natural justice principle, no?
The High Court observation was that NCLT is not bound by the Code of Civil Procedure, but he has to follow the procedure.
Natural justice principles.
Yes. In which judgment High Court held that by making it eligible for companies other than subsidiary company, associate companies and joint venture for the purpose of registration as valuer, a separate class has been carved out based on classification which is founded on intelligible differentia, and as such the rule cannot be faulted and dismissed.
Univalue projects.
And Wakefield.
Any other participant? Univalue, Jotun, Cushman
and Wakefield.
Gushman is an evaluation.
Cushman
Gushman is an evaluation.
Cushman
Yes,
and Wakefield India Private Limited.
It's an evaluation.
Sanjay ji,
Yes.
sir, in the compendium, do we have somewhere the list of case laws and the gist which are relevant to the course?
Yeah, there is a list available, no, sir. There are around 60 case laws.
And all those are applicable for us.
All those are applicable. This is the
Syllabus
IBBI
related,
list.
sir. It is in syllabus related, sir. IBBI syllabus related, sir.
This is also available on IBBI website as well.
Yes.
And the gist as well.
Yes, definitely, sir. All those case lists which are related to, which are part of our syllabus, we are only discussing those case laws here.
Okay.
Yeah. So there are 9 case laws. Let me go through the list. So, this is the list of important case law for limited insolvency exams. So Supreme Court cases, there are 20 case laws. 27.
27 case law.
Yeah. And High Court, there are 9 case laws. So this list is visible.
Yeah,
Yes, sir.
yeah.
And for NCLAT, there are again 17 case laws. Or for NCLT, there are 7 case laws.
एक DA होगा, Deputy Director of Enforcement.
Yeah, in which of the following case the High Court held that it does not appear that the asset which have been subject matter of
Tainted property, right?
Yeah. Attempting the appeal, it hand out tainted property, the same have been seemingly acquired prior to
Enforcement.
the activity. So this is the
ED
D.
case.
Leo Edible is not part of our syllabus. Dr. Vidyasagar is the related to FIR. Ultratech is not part of our syllabus. The DD.
ED case,
Director
ED
of
case.
DD. Yes.
Approved.
In which of the following case the High Court held that the resolution plan approved by the adjudicating officer is binding on the corporate CD, its employee, creditor, member, and all central and state government authority. In which case it was held? Ultratech, Deputy Director ED, Univalue Project, or Dr. Vidyasagar?
You Ultratech Cements.
Yeah, basically it was the earlier, basically it was not Ultratech, we can say it was the Tata Steel BSL, we can also refer that. That was my, basically this is the Tata Steel BSL, can also be there. Basically Ultratech तो हमारे syllabus का part है नहीं है, वो पहले था, तो I took that question. That was, Ultratech Cement was the earlier was part of our syllabus. Now when the list was revised in March 22, then this case was removed. So, but by mistake I took that question here. So next is, in which of the following case the petitioner application was rejected on the ground that petitioner was not a fit and proper person because an FIR was registered against the petitioner?
Vidyasagar Garg.
Vidyasagar Garg. In which of the following case High Court considered the writ petition filed before it is premature so as to decide the issue in question? In which of the following case High Court considered the writ petition filed before it is premature so as to Vidyasagar, because in Vidyasagar case the proceeding was undergoing in that case against that FIR. So High Court said that once the proceeding is over, the decision is pronounced by that trial court, then you can come to us. Before that, this is a premature petition. In which case the High Court clarified that in such situation as above, third party interest being prior to criminal activity, the order of attachment under PMLA remain valid and operative even though the charge or encumbrance of such third party subsist, but the state action would be restricted to such part to the value of the property as exceed to the claim of third party.
B. Deputy Director.
Yeah, Deputy Director, that one. So देखिए जो most ज्यादातर तो question can directly be asked, matter can be given, the fact of the case can be given and they can ask कि उसमें कौन सा केस लो, जस्ट जनरली इसी तरह के आते हैं, लेकिन थोड़ा सा उसमें भी कर सकते हैं, लाइक ये क्वेश्चन नंबर 10 है, उसमें थोड़ा सा उसने आपके उस थोड़ा सा वो आपको डेप्थ स्टडी की डिमांड करता है, लाइक क्वेश्चन नंबर 10, इन विच ऑफ द फॉलोइंग केस हाई कोर्ट कंसीडर्ड द रिट पिटीशन एज प्रीमेच्योर। तो वहां पे थोड़ा सा हमें जो केस लो है उनका फैक्ट पता होना चाहिए। इसके बाद जो है सुप्रीम कोर्ट के केस लो जो है, in which case the Supreme Court held that once an insolvency professional is appointed to manage the company, the erstwhile director who are no longer in management obviously cannot maintain an appeal on the behalf of the company. In the present case, the company is the sole appellant. This being the case, the present appeal is obviously not maintainable.
Innovative.
No.
Yes, innovative.
Yeah, Innovative was the case. Innovative Industries Limited. This was the first case law which
case.
was admitted by the Supreme Court. In Innovative Industries Limited, Innovative का केस लो मतलब सभी पार्टिसिपेंट को कुछ रिकॉल कर सकते हैं उसको, व्हाट वाज द फैक्ट ऑफ द इनोवेटिव केस लॉज? जी, एनीवन कैन एक्सप्लेन द फैक्ट ऑफ द इनोवेटिव केस लॉज, इनोवेटिव इंडस्ट्री केस लॉ?
In innovative case, S12 directors cannot maintain an appeal on behalf of CD after appointment of the insolvency professionals.
And something else?
Initiation of CALP by financial creditors only.
Financial creditor. And also, if there is a default by, like there are two financial creditors, if there is a default by financial creditor 1, the application can be filed by the, on default of against the financial creditor 1, application can be filed by the financial creditor 2, even though there is no default has been committed against financial creditor 2 by the corporate debtor.
The question is, the question is that whether the suspended board of directors, board is suspended once on appointment of IRP, that suspended board of directors can file a case on behalf of the corporate debtor in the court. That is the issue.
Yes, but RP can only file.
RP can only file. Suspended board of director cannot file.
Cannot file. That is the issue.
Yeah.
Yes.
And another issue is there. Maharashtra Relief Undertakings.
Maharashtra Relief Undertaking Act, can the provision of Maharashtra Relief Undertaking Act override the provision of IBC?
Yeah, these two issues are involved.
In Innovative Industries Limited versus ICICI Bank and another, the Supreme Court made the
In
following
which,
observation.
in Maharashtra Relief Act or IBC, which will prevail?
IBC
In the
will
case
prevail.
of conflict, IBC will prevail.
Yeah.
IBC, because Maharashtra is in a state act actually. IBC is in a ID first. That's actually it.
If there is a conflict, the Central Act will prevail.
Yes, sir. Can anyone read the section? Sorry, MCQ 13.
In Innovative Industries Limited versus ICICI Bank and another, Supreme Court made the following observation. A default is in respect of financial debt or operational debt owed to a financial creditor or operational creditor of the corporate debtor. It need not be debt owed to the applicant financial creditor or operational creditor. B. A default is in respect of financial debt owed by to any financial creditor of the corporate. It need not be debt owed to the applicant financial creditor. C. A default in respect of operational debt owned by an operational creditor of the corporate debtor. It need not be debt owed to applicant operational creditor. I couldn't understand it.
None of the above, or D, none of the above.
None
Like-
of the above is correct, sir.
No,
Because
there are,
operational debt.
B.
like there are two operational creditor 1 and operational creditor 2, and the two financial creditor 1 and financial creditor 2. So default has been default has been made in the payment of operational creditor 1, OC1 and FC1. So can FC2 or OC2 file the application?
Yes.
OC2 can file the application because
Yes,
but
yes,
the
sir.
default has not been committed against OC2.
Fir bhi, if it is committed by some other person, they can file.
That is first thing. The first our question is, can in Innovative Industries Limited case, what was the decision of the Supreme Court? Is for the both OC and FC, or only against FC, or
Only against
OC?
FC.
So it was only against FC in this case. In Innovative Industries Limited, Supreme Court observation was that if there is a default against any of the financial creditor, then any one of the financial creditor can file the application under Section 7. This was
Even though
Yes.
there is no default of his account.
if there is no default directly for the against that financial creditor. Like ICICI Bank has given loan and Axis Bank has given loan. Default is against Axis Bank. So ICICI Bank can file the application under Section 7.
But even in the case of operational creditor also.
No, then it is not there. Operational creditor can only file the application if default has been committed against that operational creditor only.
Okay.
But when there is no default to this bank, sir, why this bank will go?
Because in longer run, there
They
is
will
a
face
default
the
against
problem.
one financial creditor, then there can be default against that bank as well.
Okay, right. Thank you, sir.
Specific regulation or just the case law?
No, it's a specific regulation as well. If you read the section, particular section, it is clearly mentioned.
Section 7.
Section 7, yes. So next is out Mobilex Innovation Industries Limited.
What is the correct answer of question 13?
B. A default in
B,
respect
B.
of the financial debt owed to any financial creditor.
Oh, B is the correct answer.
Yes. Next is out of the following case, which issue was involved in Mobilex Innovation Private Limited versus Kirusa Software? So can you first anyone explain about the Mobilex Innovation? So only few facts just to recall that case law.
Existence of
Actually, the
dispute.
Kirusa has break the non-disclosure agreement with the Mobilex.
Mobilex, yes.
NDA.
Yeah, Mobilex there was a so famous show Nach Baliye. Mobilex has some Mobilex was taking care of the technical part of that show, like online voting and other application. So he has outsourced some part of his work or of his contract to the Kirusa Software, and he has signed an NDA. After 1 year of outsource of the work, but that was from the retrospective application, retrospective NDA, that Kirusa Software will not disclose that he has outsourced by the Mobilex related to the work of Nach Baliye show, but he disclosed on his website. So this is the fact. So now can anyone read this question and then we can go ahead.
The following issues, which issue was involved in Mobilex?
Whether there is an existence of between concerned parties or a record of pendency of suit arbitration proceedings. B, existence of dispute between concerned party, record of pendency suit, arbitrary demand notice. Before, yes, B, sir.
And what is the C and D? Please read that as well.
Whether period of 7 notice applicant for rectifying defects in the mandatory, that is for application.
Yeah. So
Whether
why B,
period
sir?
of
Why not A? Because there is a similar language in A and B. Then what is the difference between A and B?
That
Whether there is-
demand notice, before receipt of the demand notice, the dispute should be there, not after that.
Yes. So the generally to the right nowadays, what is the trend that they have the almost in the two or three answer of the MCQ, they have the almost similar language. There is only play of 2 or 3 words, like in this case, whether there is an existence of dispute between the concerned parties or any record of pendency of suit or arbitration proceeding. And there is also the B answer is the same, whether there is an existence of a dispute between the concerned parties or any record of pendency of suit or arbitration proceeding filed before the receipt of demand notice. So that suit there's the in this case, Supreme Court said that the dispute must be pre-existing before the demand notice under Section 8. Next 16, can anyone read?
In which case Supreme Court laid down proportions relating to rebenency and application of doctrine of fifth and substance. Case Shashidhar versus IOB, Mobilex Innovations versus Krisha, Swiss Brands, another versus Union of India, Innovative Industries.
Which one? Basically, doctrine of repugnancy and was because in case of Innovative Industries, there are two act was parallel was there who are both the act were applicable on the same situation. Like in Innovative Industries, one was the Maharashtra Sikh Industrial Act, which was applicable to the Sikh companies and the IBC. So there was a repugnancy. Both acts are repugnant to each other. So doctrine of repugnancy was basically was applicable in this case. So the answer is Innovative Industries Limited versus ICICI Bank. Next question is in which case Supreme Court held that all that the AA is to see at this stage is whether there is a plausible contention which require further investigation, and that the dispute is not a patently feasible legal argument or only an assertion of fact unsupported by the evidence or not supported by the evidence. The dispute is like only an assertion of the fact which are not supported by the evidence. So it is important to separate the grain from the chaff and to reject a spurious defense which is mere bluster. However, in doing so, the court does not need to be satisfied that the defense is likely to succeed. So in which, like Anuj Jain, Chitra Sharma, State Bank of India versus Matrix or Mobilex Innovation. Anuj Jain में मैं आपको बता देता हूँ in case of Anuj Jain versus JP Infra, there was the two issues was involved. One was related to the POF transaction, and second was related to the because some property of JP Infra has given as mortgage to the lender of the holding company of JP Infra, JP Associate Limited. So the financial creditor of JP Associate Limited approached the JP Infra and said that we are your financial creditor because you have given your property as a mortgage to us. So these are the two issues involved. Chitra Sharma was related to the real estate case. State Bank of India versus Matrix was related to appointment of an retired bank employee as a RP. And Mobilex was a dispute. Mobilex, as we have already discussed. So which case is the answer?
Mobilex.
Mobilex is the
Sir,
answer.
one thing I am asking you, what's the meaning of plausible contention here? There is a plausible contention which requires further investigation. What's the meaning of plausible contention here?
Plausible contention means we have to see that what is the dispute. Dispute is quoted by the some evidence, or only we can say only a assertion of the fact. Only the contention is there. Like
no, whether the dispute have actually they did not go into the merits of the dispute, no, sir.
Sir, I
Court
think
said
it is reasonable. Plausible means I think it is reasonable, justifiable.
reasonable contention.
Reasonable.
I think that might be the answer.
I think that plausible means reasonable contention.
Reasonable,
right.
or you can say justifiable.
Justified, they're right. Justified contention.
next is Limited received a demand notice under Section 8 from an operational creditor on 15th of January 2021 for non-payment of their dues, against which A Limited replied stating that since the operational creditor violated the terms of the NDA, the payment was stopped, and this was brought to their notice the moment violation came to the notice of A Limited. The operational creditor filed an application under Section 9 of against A Limited. The application of the operational creditor should be the light of the fact and ratio decided by the Supreme Court, in which either accepted or rejected, and which case has to be referred. So accepted Mobilex Innovation Limited, accepted Dharani Sugar, rejected Mobilex Innovation, or rejected Dharani Sugar.
Rejected, sir. Rejected Mobilex.
All are agree? Is it accepted or rejected?
Rejected, sir.
Rejected.
पर सर धरनी शुगर्स का मैटर क्या है ये तो पता होना चाहिए ना.
RBI का circular they said it is an ultra virus of the constitution, and
RBI
So
circular
this-
of the strays asset.
yes, that
Under
was
section 37 of the RBI Reserve Bank of India Act.
it.
Basically, हम पहले we have already discussed these all the case laws in the I think 2 weeks before. So then it was the idea was came कि we should also discuss some MCQs so that participant can come to know that how the question is being asked. So I have prepared some around 44 MCQs. So it will give you a fair idea how the question can be asked. So we are discussing
Okay,
those
okay,
as
okay.
MCQs.
Very good, sir. Good.
Yes, sir. Last time we ourselves asked how the questions will be framed on the case law, sir. But you have prepared this.
Well, sir. Very good.
So this is a basically these MCQ will give you a fair idea how in depth the question can be asked. So we should know in the Dharani Sugar there was RBI circular which says that if there is a default of 2,000 crore is there, then the IBC application has to be filed by the banks. So it was a journal circular which was challenged in this case. The next is the test of bona fide dispute as unicated in Madhusudan Gordhandas versus Madhu Woolen, rendered under the Companies Act 1956, does not hold good under the code, was held by the Supreme Court in which case? Swim Water Treaty, Mobilex, Chitra Sharma, or Swiss Ribbon. So first, what was the decision which was unicated by the Supreme Court in Madhusudan, and then in which case it was decided that now it does not hold good? The decision of the Supreme Court in Madhusudan Gordhan was that default of payment by a company cannot be a ground of winding up of a company. So this was the decision. So can you anyone explain that now which can be the answer? देखिए चित्रा शर्मा was a real estate case related to the real estate, so it is out. So we will Swiss Ribbon was there are many this different aspect of the IBC was challenged in case of Supreme. In case of Shivam Water Treaty, power of NCLT has been challenged. So there was a case of Mobilex Innovation Private Limited was the case in which Supreme Court held that this Madhusudan Gordhan decision was referred because this was also related to the payment dispute. So Mobilex Innovation is the answer, B.
Sir, can you please share this along with answers, sir, the group?
Sir, I have not made any answer sheet for those MCQs. But when you read the case laws, then you will refer these MCQ, you will get the answer in most of them.
But these questions, you please kindly share, sir.
Yeah, that I will share, sir. That.
Thank you, sir.
So, question, can anyone read the 20th MCQ?
In dash case, Supreme Court ruled that the application under Section 9 would have to be rejected if the adjudicating authority finds that the following condition is lacking. Mobilex Innovations Private Limited versus Krisha Software Limited, there is an existence of dispute between the parties or the record of the pendency of a suit or arbitration proceeding filed before the receipt of the demand notice of the unpaid operation debtor in relation to such dispute. In Shivam Water Treatise, Union of India, there is an existence of a dispute between the parties or the record of the pendency of a suit or arbitration or other proceedings filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. Third, Union of India versus Association of Unified Telecom Services Providers, there is no existence of a dispute between the parties or the record of the pendency of a suit or arbitration or other proceedings filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. Fourth, the Committee of Creditor of Steel Limited through authorized signatory versus Satish Kumar Gupta, others, there is no existence of a dispute between the parties or the record of the pendency of a suit or arbitration proceeding filed before the receipt of the demand notice of the unpaid operation debtor in relation to such dispute.
C.
Union of India versus Association of Unified Telecom Service Provider. This one, C. It is related to Section 9. Section 9 means operational creditor. Application of
Mobilex.
Mobilex, yeah.
Mobilex. Section 9 or Mobilex.
Mobilex.
Yeah. In which of the following cases Supreme Court held that one of the important objectives of the code is to bring the insolvency law in India under single unified umbrella with the object of speeding up of the insolvency process. There is an innovative industries.
Yeah, basic Hukamdev is not part of our syllabus. Innovative part of our syllabus. Mukri Gopalan is not part of our syllabus. And BK Educational, it is related to the Limitation Act.
Yes.
So innovative is the answer. We can also
Innovative.
Yeah, we can also basically carve out some option like this if did not.
Sanjay sir.
Yes.
Sir, we can find out the list of case studies there, but then do we get from you or from the IBA the gist of relevant case studies which are applicable to us?
Yeah, it is there.
Your case laws.
Only case laws list is there, but the small summary or the executive summary or the major points that have been raised
in relation to case law.
Right.
No, there cannot be any. They cannot. They can ask any, basically any fact of the question on any fact of the case law. So there cannot be relevant, any relevant summary or any like study on like this that. Because there are some case laws which are in very lengthy. So I don't think so. अगर कोई ऐसा
Sir,
कुछ available नहीं है,
the issue we can tell, issue is easy to remember. What is the case? The question is comments made by the Supreme Court. That is to link that it requires study of entire case.
the only solution, one thing we can do is like we can understand the case law like a story, like like nowadays Adani story is going on, so many know in detail the Adani story. So
No,
we-
it is very difficult to remember the 60 case law, sir. It is very difficult to remember.
That's why it's exam.
I have already read it 3 or 4 times, but I could not remember
See,
it.
when you will read like a concept or when, but till the time
Concept
when you
is
read
clear,
like
but
it's a story,
it is very difficult to remember.
yeah, it's very difficult to remember. But though there are 4 options, so if you read 2 or 3 times, then you can answer, I think.
So the solution is to
Answer
read.
of 22, what is the answer of 22? 250, Article 254.
In Innovative Industries Limited versus ICICI Bank, the Supreme Court delved into case law and constitutional principles surrounding repugnancy between central and state law in context of Article 254, the doctrine of repugnancy, which was decided by the in case of Innovative Industries Limited. In which case law the Supreme Court held the word and appearing in section 21 in section 8 subsection 2 must be read as or in the reasoning given by Supreme Court was Mobilex in order to further the object of the section 8 to avoid an anomalous situation. Innovation Industries to give effect to the Bankruptcy Law Reform Committee, Mobilex, in order to further the object of the statute to avoid an anomalous situation. And ArcelorMittal, in order to further the object of the part 2 of the code to avoid an anomalous situation. So basically the answer between
Mobilex.
A and C, which is the answer? Answer is C, Mobilex
C.
Limited to further the object of the statute, not the object of the section 8, basically. The end can be read as or to further the object of the statute. So there is minor difference of only section 8. Here section 8 is mentioned. Here the statute is mentioned. All the wording language is same. Other language is same. The next is which is related to Dharani Sugar, which case section 35A AA of the RBI is. So this is related to the Dharani Sugar and Chemical Limited. Now this is a good question. The Supreme Court in Mobilex Innovations Private Limited versus Crusoe Software has interpreted the term. Which term has been interpreted by the Supreme Court? Operational creditor, time value of money, existence of dispute.
Existence of dispute.
Yes, existence of dispute. Or the doctrine of repugnancy.
Answer A. 3 of the
C.
Limitation Act.
See. Acha. The issue involved in case of BK Educational Private Limited versus Parag Gupta. In case of BK Educational, this case is related to the applicability of the Limitation Act on the IBC proceedings.
A.
C.
C is the answer. Both A and B.
Both A and B.
Yes. In which of the following case Supreme Court held that the provision of Limitation Act shall apply to the proceeding or appeal before the AA, the NCLT, the DRT as the case may be. Macquarie Bank Limited is not part of our syllabus. Innovative has a different note related to the Limitation Act. Siom Water Treaty is also not related to the Limitation Act. And
Okay.
BK educational there and the limitation.
Yeah. ये एक बार हम थोड़ा आगे चल लेते हैं इससे। हम चलते हैं, कुछ लास्ट के केस लोग हैं कि एमसीक्यू वो थोड़े से अच्छे हैं। So ये क्वेश्चन भी अच्छा है। Which court held that the remedies given to the lottery of the flat under the Consumer Protection Act, RERA, as well as RERA and Consumer Protection are the concurrent remedies. Which court held that the remedies given to the lottery of the flat under the Consumer Protection Act, RERA, as well as RERA, that the triggering of the code are concurrent remedies. So basically, if we can refer the Chitra Sharma case we have discussed, and that pioneer case. So Supreme Court has given the decision that the RERA, Consumer Protection, and the IBC are the concurrent remedies.
What is the concurrent remedy, sir? Meaning?
Meaning ki as a flat owner, you can go to all the three forms simultaneously. Consumer form, RERA, as well as the you can trigger the IBC as well.
You can
go off any of the option or all the options. Concurrent.
Muted, sir. Muted, sir. Administrator, please mute the.
Muted, sir. Muted. Now we are directly coming on the MCQ 37. A Limited, who has submitted a resolution plan, has been declared ineligible under section 29 of the code, and the decision of COC was conveyed to A Limited. While the committee COC is considering resolution plan filed by other resolution applicant, namely B Limited and C Limited, are under consideration with the COC. A Limited approached you for advice as to the next course of action. What will be your advice based on the decision of Supreme Court in case of ArcelorMittal versus Satish Kumar Gupta?
Yeah.
So, first, can anyone explain what is the issue, the fact of the ArcelorMittal case, if anyone can recall? Basically, in case there was a corporate debtor was SR Steel. So SR Steel was a big corporate. So the Satish Kumar Gupta was the resolution RP of the SR Steel. ArcelorMittal and one another company name was, I'm not able to recall.
New Metal.
Yeah, which? So ArcelorMittal and one another company was the resolution applicant, and they submitted the resolution plan, but RP, the Satish Kumar Gupta, has rejected the resolution plan because the issue was that they were both were not eligible under section 29 of the code. So that when the eligibility has to be checked, on which date is on the submission of the resolution plan or on the date of initiation of the CIRP was the issue. So on that question, in this case, what is the option available with the A Limited? A Limited submitted the resolution plan that was not considered by the COC. They are considering the plan submitted by the B and C Limited, B Limited and C Limited. So what can A Limited do? Can he file
Yes, sir. Yeah.
can file an application before the AA immediately against the decision of COC, file an appeal before the AA under section 61 of the code. No application of appeal lies at this stage, file a writ petition before the concerned High Court.
Yeah.
On what basis, sir? Because
Then
his
the-
plan was
decision
because-
of the COC, decision of the COC declaring him as a ineligible person under 29A.
Actually, no answer is C. No application of appeal lies at this stage.
if
The resolution
the
applica-
fact
the-
that he can challenge the ineligibility, but if he is actually ineligible, then why in what case the option is available?
No, sir. They are conveyed to him, he is ineligible.
Yes.
So that if he is not happy with the decision, he can challenge before A. Under section 65, 60 subsection 5.
In case of B, under section 61,
No, 61 no appeal lies.
now what is that section 61 says?
देखिए जो ये क्वेश्चन है ना which the question was basically is that if the plan was rejected because you are not declared you are ineligible, then you cannot, and you are actually really ineligible, then you cannot file any appeal against that decision of the COC.
Sir, if he feels that, suppose he feel I am not covered under 29A.
If you feel that he has to declare that section 29A say that he has to give an affidavit that he is eligible under section 29A.
Yeah.
Yeah. So
At the submission,
not
at
like
the time of submission of the resolution plan,
yeah. So
he has to state that
he has to give an affidavit
Hmm.
that he is eligible under section 29 of the code, and later on if he is found ineligible, then though that can be challenged, but if it is clear that he is ineligible under section 29A, then he does not have any option.
Now that this decision is taken by the COC that he is
COC.
ineligible. He can go against the COC to the appellate authority, adjudicating authority.
Resolution
He
applicant
can
cannot be
challenge.
challenge. He cannot challenge
The
only at the time
prospective
of
applicant can challenge it. to
Only
the-
applicant can challenge. If he wants to,
he can.
he feels that
cannot
he is
challenge.
eligible, he is not attracting the section 29A. If he feels that, but committee of creditors feels that he is attracting that, then he can challenge that decision. If he agrees, there is no decision.
So he can go to the appellate adjudicating authority. It's
A,
open.
A is the answer, B is the appellate authority. He cannot go there.
A is the answer. A is the answer.
So next, can anyone read this MCQ 38?
But do you agree, sir? A is the answer?
Yes.
Okay.
If देखिए, if he is clear that he is ineligible, then he cannot. There is no answer is C. No application of appeal lies at this stage because he is ineligible. But if he wants to challenge that ineligibility, then he can. The appeal lies. The answer is A. MCQ 38. Can anyone read?
In an ancillary Metal India Private Limited, Mr. Satish Kumar Gupta and others, the Supreme Court held that the ineligibility to submit a resolution plan attaches if any person who either itself has an account or is a promoter or in the management or control of a corporate debtor which has an account which account has been classified as a non-performing asset for a period of at least 1 year from the date of such classification till the date of commencement of the corporate insolvency resolution process. B, date of submission of resolution plan. C, date of approval of the resolution plan by committee of creditors. D, date of approval of resolution plan resolution by adjudicating authority. The A is the answer.
A is the answer.
A is the answer. Date of commencement.
Yes, date of commencement of the CIRP.
Yes.
Next is in which judgment of the Supreme Court held that the RP is not required to take any decision, but merely to ensure that the resolution plans submitted are complete in all respect before they are placed before the COC, who may or may not approve it. Basically, how the
ArcelorMittal.
Arcelor versus Satish Kumar. See.
Yes. This is very important case, ArcelorMittal.
And Satish Kumar. Yes.
In which case the Supreme Court concluded that the RP is a person who is not only to manage the affair of the corporate debtor as going concern from the stage of admission of an application under section 7(9) of the code till a resolution plan is approved by the AA, but is also a key person who is to appoint and meeting, who is to appoint and who is
ArcelorMittal.
Yeah.
Satish Kumar Gupta.
To manage the meeting of the COC so that they may decide upon resolution plan that are submitted in accordance with the detailed information given to the RP resolution applicant by the resolution professional.
B. Same, more or less same fact of 39 question.
Nini, more or less the same fan. No, there are difference. There are there are committee of creditor versus SR Steel is also there, na?
Committee of creditor versus Satish Kumar. A.
Which A or B?
A.
B.
It's A, sir. A. Because in that case, the role of NCLT and plate and everyone has been decided by the Supreme Court. Let me go through that case law. अभी आपको are you able to see the PPT?
Yeah.
Yes, sir.
So committee of creditor. So role of RP. The court concluded the RP is a person who is not only manage the affair of the corporate debtor as going concern from the stage of admission of an application under section 7, 9, 10 of the code till a resolution plan is approved by the AA, but is also to a key person who is to appoint and convene the meeting of the COC so that they may decide upon the resolution plan. The role of RP, role of PRA, prospective resolution applicant, role of COC, jurisdiction of NCLT and NCLAT, the constitution of subcommittee. These are the matter which has been decided by the Supreme Court in case of that committee of creditor of SR Steel. Utilization of profit of the corporate debtor during CIRP. So So in which of the judgment the Supreme Court held that what is left to the majority decision of the COC is the feasibility and viability of the resolution plan. Anuj Jain's ArcelorMittal, COC of SR Steel or Innovative Industries Limited.
Statement subpoena header, what is left to the majority decision of the committee of it.
C, that is 3.
COC, yeah, COC of SR Steel. Because in that case, case of COC of SR Steel, Supreme Court has decided about the role of different like resolution applicants, COC, RP. The ratio, question is the ratio.
আমাদের 300 টাকা হয়ে যাবে না ডাল আনবো
না না অনেক
হ্যাঁ
300 অনেক
The ratio that the resolution plan that was submitted to the resolution professional are hit by section 29A, and since the proviso to section 29A will not apply as the corporate debtor have not paid off their respective NPAs ordinarily, these appeal would have been disposed of by merely declaring both resolution applicant to be ineligible under section 29A was laid down by Supreme Court in which of the following case?
ArcelorMittal.
ArcelorMittal, yes.
D.
Actually में इसमें ऑप्शन जो है ना वो
या ऑप्शन से बोला मैं.
हाँ इसके ऑप्शन चेंज करने पड़ेंगे ना, कंफ्यूजिंग वाले होंगे तो बड़ा मुश्किल है.
Yes, sir. Actually.
Which of the following issue was involved in case of K. Sasidhar versus Indian Overseas Bank?
Yes, either
Can anyone read the option?
Whether the percentage of voting share of financial creditor specified in section number 34 of the code is mandatory. The second, whether it is open to the adjudicating authority, appellate authority to reopen any other factor other than those specified in section 32 and section 61(3) of the code, which according to the resolution applicant and the stakeholders supporting to the resolution plan may be relevant. Third, role of resolution professional in resolution plan. Fourth, whether the amendment dated 6th June 2018 to section 34 regarding the voting percentage is prospective or retrospective.
Basically, can anyone explain the K. Sasidhar versus Indian Overseas, the effect of the K. Sasidhar versus Indian Overseas Bank? Basically, in this case, there was some change in the percentage of COC meeting. Earlier, it was any resolution was passed by 75%. Then the resolution plan was approved.
66%, right?
It was made to 66%.
Yes.
So this was the case. So the one option is whether the percentage of voting. So one is there. Whether it is open to the AA appellate authority to retain any other factor. This is basically apart from this, they also said that they have to the resolution plan should also be accepted that because there are some other factor they have also taken the play of, some other factor they have mentioned in the appeal. So role of resolution applicants. So the answer is all of the above. D. Next, a resolution professional has approached you for advice as to whether the COC can constitute a subcommittee. Please provide your answer on the basis of judgment of Supreme Court in COC of SR Steel versus Satish Kumar Gupta. Subcommittee can be constituted by the COC for all the purpose without any restriction of the purpose for the purpose of negotiating with the resolution applicant, for the purpose of performing other ministerial or administrative work, provided such act are in the ultimate analysis approved and ratified by the COC. One option is there. Second is no subcommittee can be constituted by the COC. Third is subcommittee can be constituted by the COC for all purpose without any restriction, provided all such act are in
This
the
is-
ultimate analysis approved and ratified by the COC.
See, answer, see,
Subcommittee can be constituted by the COC for all purpose without any restriction. The purpose of negotiating with the resolution applicant, for the purpose of
Person
other ministerial and administrative,
negotiating
and
with
no
the
ratification
resolution
by the
applicant
COC.
for purpose of performing other ministerial.
So which is the answer?
C.
Let's go to the case of COC. So the constitution of subcommittee by the COC.
Kina Padri. Huh? Padri. Maki ko Padri.
ঠাকুরমণি তোমাকে কি সব বলছে দেখো। ঠাকুরমণি তো
The just we are referring the COC of SR Steel law. The constitution of subcommittee by the COC. When it comes to the exercise of COC power on question which have a vital bearing on the running of the business of the corporate debtor. Section 28, subsection 1, subsection H provide that though these power are administrative in their nature, they shall not be delegated to any other person. Meaning thereby the COC of alone must take the decision mentioned in section 28 and not any other person, not any person other than such committee. When it comes to approving a resolution plan under section 30 subsection 4, there is no doubt whatsoever that this power also cannot be delegated to any other body, as the COC alone that has been vested with the important business decision which it must take by itself. The court, however, noted that this does not mean that subcommittee cannot be appointed for the purpose of negotiating with the resolution applicant or for the purpose of performing other ministerial or administrative act, provided such act are in the ultimate analysis provided and ratified by the COC. So court has clearly made that for all the act of the COC, subcommittee cannot be made, or all the act of the COC cannot be delegated to the COC. They have mentioned some act like negotiating with the resolution applicant for the purpose of other ministerial and administrative act. So this is very important. So our answer should be like see all such act are in ultimate analysis without any restriction for all purpose. So for all purpose, COC cannot delegate its power to the subcommittee. So answer is A, not C. Because like approval of resolution plan, so that cannot be delegated to the subcommittee. So all the power of COC cannot be delegated. Clear?
Subcommittee can create a power without any restriction. A is the answer, sir.
A is the answer, yeah.
What is the question?
Sorry?
So they can constitute, no?
They can constitute the subcommittee for, but not all purpose. Like they can constitute the subcommittee for like administrative purpose, other ministerial purpose, negotiating with the resolution applicant.
Okay.
So these are the MCQs that I have made.
Very
There can
interesting.
be
Sir.
many other
Interesting.
MCQs on different case law, because if I may, for each case law, if I made a MCQ, then it will be a long list again.
The daily we have to read this at least.
Yes.
देखिए, we can what we can do is what is the best option is that we can read the Supreme Court case law, High Court case law, and some related case law of NCLAT. That may also cover.
Yes, sir.
Because
अभी हाई कोर्ट बंद हो गया ना सर?
High Court, nahi, it's part of our syllabus.
No. Now they are not giving any judgments, no?
नहीं, High Court में जो भी case laws है ना, they all are writ petition, not any judgment. और High Court में IBC के matter नहीं जाते हैं, only writ petition can be filed in High Court. So
Supreme, whether I am not remembering the judgment or the advice to the High Courts that you don't interfere with the interpretation of IBC. Such advice is given to the High Court, sir.
In one case, it was advised because the High Court has given an order to stay the proceeding of the IBC. But if you can file if you want to file any writ petition related to the IBC, any matter of the IBC, then you can file any writ petition to the. That is the right provided by the Constitution.
Yeah. That's the Supreme Court cannot advise writ jurisdiction restrictions.
Yes. So all the 9 case law of the High Court are the writ petition only.
Okay.
Yeah. Now we will go through the pending case law of the IBC, which are related to the. We have discussed till Era Infra versus Periodico Commercial. Till last our discussion, we have discussed Era Infra. Now it's Ramesh Kamal versus Siemens Gamesa Renewable Private Limited. Just I will brief in 2 lines about the cases. This application was filed by the operational creditor on 11th of May 2020 under Section 9 of the Code against Siemens Gamesa Renewable Power Private Limited. And the default was of amount of 101 CR against the CD. And the date of default was 30th April 2020. It is a very important case law, basically, for the practical purpose. So what happened after the filing of the application, the COVID came into the picture and government issued a ordinance. During the pendency of the proceeding, ordinance number 9 of the 2020 was promulgated by the government on 5th of June 2020, which says that, which inserted a section 10A of the code, which suspended initiation of CIRP against under section 7, 9 or 10 of the code for any default arising on or after 25th of March 2020 for a period of 6 months. So this ordinance was issued for a period of 6 months, which says that if during the period of this ordinance, if there is any default, the proceeding under section 7, 9 or 10 cannot be filed in the lifelong. So this is very important. Even there are many case study question has been asked in the exam. Again in this basically on section 10A, because during the period of the ordinance, which was of 1 year, in first instance it was for 6 months, then again it has been extended for the next 6 months. If there is a default in that period, that COVID period, first lockdown period, then the application under IBC cannot be filed during the lifetime of the company. And so this was the case. So the application of Ramesh Kamal was rejected, and he said that so since that 10A section 10 has been brought by the government and it is applicable from the retrospect, it is applicable from the 25th of May 2020. So application cannot be filed. It is very important case. Sometimes this question can be is being asked in the case studies, not in case law, in under section 10A or this case. They given the date that application the default was related to the April 20 period or June 20 period, and they will ask a question that can the application be filed under section 7 or 9, or what is your advice to the financial creditor or operational creditor. So it is very important case law. SC Sekran versus Amit Gupta and Clate. Basically, there was two corporate debtor, Hindustan Door Oliver and HDO Tech Private Tech Limited. And in both the cases, the liquidation order has been passed. So the management of these companies wants that even during the liquidation, the company has to be the liquidator has to sold the company as the going concern, or in has to sold the company going concern. So they approach the enclate. So whether the liquidator keep the corporate debtor as going concern even during the period of liquidation, whether the liquidator can take step under section 230 of the Companies Act after consultation with the member or the creditor of the companies for making arrangement with the third party or third party after thereafter take approval of NCLT, or whether the order of A directing liquidation of the CD deserve to be set aside. Basically, what management appeal is that either the liquidator has to solve the company as going concern, he has to try first to solve the company as going concern during the liquidation, or to sold the asset in one go. First he has to basically made some effort to sold the company as going concern, or to sold the asset in one go without being separately sold the asset. So what the decision of the Supreme Court is that Supreme Court putting the reliance on the Supreme Court judgment in case of Swiss Ribbon case and ArcelorMittal had that even in liquidation, the liquidator can sell the business as going concern. And they can make the compromise or arrangement under section 230 within 90 days of under section 230 of the Companies Act. Liberty House Group versus State Bank of India. This is also the enclate case, in which case there are two corporate debtor, Adhunik Metallic Limited and the another is Gion Steel Limited. And there was the one resolution applicant for both the corporate debtor, that is Liberty House Group was the successful resolution applicant. Basically, he did, when his plan was approved, he did not took step to implement the plan. First, the Liberty House did not take any step to implement the resolution plan. Then he submitted that there was a 50 crore of deposit which was made by the Liberty House Group. When the resolution plan was submitted, he said that 50 crore should be adjusted in the upfront payment, which is as per the resolution plan. There was a provision of upfront payment in the resolution plan. So he requested that 50 crore which he has given as security during submission of resolution plan should be adjusted in the upfront payment. The NCLT and NCLAT has given some additional time, extended period of 30 days to implement the resolution plan to the Liberty House Group. Even in that period, he did not took step to implement the resolution plan. So the COC approached the NCLAT that since the Liberty House Group has not implemented the resolution plan, so COC moved an application for the COC moved an application for reinitiation of the CIRP and allowed to consider the other resolution plan on the ground that Liberty House has failed to implement the plan within the extended period of 30 days. When the extended period allowed, Liberty did not took any action. Then COC moved an application that we should allowed to reinitiate the CIRP and to consider the other resolution applicant. Then the request of the COC was not considered, and the order of liquidation has been made in case of Adhunik Limited and the Geon Steel Limited. The A also refused to grant further time to the COC to consider the resolution plan. But after the order of liquidation, the Liberty House Group filed an affidavit to allow it to comply with the resolution plan and to set aside the order of liquidation of both the aforesaid. After the order of liquidation, Liberty House Group filed an affidavit. Then the again matter was heard, and his affidavit has been considered. He has been allowed. So after hearing both the parties, they have been allowed one another opportunity to implement the resolution plan. So if we refer the point number 7, after going through the affidavit and heard the learned counsel for the appellant, learned senior counsel appearing on the behalf of the COC and the bench, and now the bench is of the view that in the interest of the stakeholder, financial creditor, operational creditor, employee, the period of compliance of both the resolution plan is extended, and who otherwise will suffer a liquidation. So they have extended the period of compliance. We allowed the successful resolution applicant to file undertaking giving time frame of compliance of both the plan by depositing the amount as offered in their approved plan. So what was the proposal? The proposal of implementing the resolution plan was that Liberty House Group will deposit 360 crore for Adhunik and 10 crore for Geon as full and final settlement. The liquidator of Adhunik and Geon will demit office on aforesaid deposit, and as per the resolution plan, all the past director of Adhunik and Geon shall demit office, and Liberty House Group will be entitled to appoint all the director of the board of both the CDs to complete all requisite step. So after all the compliance, after this affidavit and the proposal, Liberty House made the deposit. He made all the compliance, and the final order of the enclave was came on 17th of February 2020. Learned counsel for the appellant submitted that the amount in terms of the earlier order dated 21st January 2020 has been paid. Learned senior counsel appearing on the behalf of COC has also accepted the same. So in the view of the development, the order of liquidation is stayed, and the liquidator will function as a resolution professional. So it is also, so there are many, you can say, turn in this case. First, the resolution applicant did not implement the resolution plan. The COC approached to the enclave that we should be allowed as to reinitiate the CIRP. Their appeal was not accepted. The liquidation order has been made. Then the resolution applicant approached and filed an affidavit that he will implement the resolution plan. Then the proposal has been decided, and the time has been given to implement that proposal. And after the implementation of the proposal, they approached the enclave, and the enclave had stayed the liquidation order. So in the matter of Aircel Limited enclave, this is enclave case. Aircel has gone into the IBC. Aircel himself has applied under section 10. So basically they have the spectrum across India. So their fear was that when after the approval of the application, the Department of Telecom can cancel their spectrum. So they requested the NCLT to direct the Department of Telecom to not to cancel their spectrum, so that they can be sold as going concern. Because if the spectrum will be cancelled, then there is the company, there is basically there is a question on the going concern of the Aircel. So just after to conclude the bench, I will read the decision of the enclave. To conclude the bench is the view that admittedly the license of spectrum is the asset of the state over which the CD has no right of ownership. Therefore, up to this extent, the argument of government is hereby accepted. Hereby instruct the concerned DOT authority not to make any attempt to cancel the impugned license issued in favor of the debtor company. Both the applications are disposed of and ordered accordingly. In the matter of PAL Infrastructure and Development Limited, basically there is a provision, there is a section 25A, subsection 3A, which says that in case of the home buyer, the class of creditor, if there is a class of creditor who approve any matter with more than 50%, then it will be treated as 60%. There is one provision is there in section 25A, subsection 3A, capital A. So there is a provision. So in the matter was that they in the council appearing. So the council appearing on the behalf of 3 allotee association has stated that in the second COC meeting, the class of allotee, that is home buyer, that is comprised of 72% of the voting of the COC voted for replacement of the IRP with the RP with the voting share. So 72% of the COC voted of that class has the 72.39% of the COC voting. That class of financial creditor, the percentage 38.92 has voted in favor of the replacement of the RP. So it is more than 50% of the 72%. So as per the provision of section 25A, subsection 3A, the approval of more than 50% shall be treated as 100% on the behalf of the home buyer as to the resolution passed by the COC as contemplated under section 25A, subsection 3A of the code. But the RP took a stand that while the IRP has not moved an application for replacement of the on the premises that the allotee voted in favor of the approval is far below 66%, because 38.92 is not the 66% of the 72. So far below 66% of the voting share of the total voting without taking subsection 3A of the section 25A of the code into consideration. So when the matter goes with the NCLT, so what the bench asked for IRP to whether meeting has taken place and voting has been done as stated by the applicant council. The IRP considered that in the second COC meeting, resolution was proposed and voted as stated by the applicant. So on looking at the scenario, then the NCLT was the view that no further inquiry is required. Therefore, we arrived to a conclusion that the resolution passed by the COC is with more than 66% of the approval of the replacement of IRP with RP. Hence, the application is hereby allowed for replacement. So our NCLT also upheld the basically applicant view that related to the section 25A, subsection 3A. In the matter of Jet Airways, so when the IBC proceeding under in the NCLT has been started against the Jet Airways, so what happened? The one company, the IBC proceeding against the Jet Airways also going on the same time in the Netherlands. So during the hearing, bench was appraised that IBC against the CD, that is Jet Limited, has already been instituted in the Netherlands, and it translated copy of the judgment of the Netherlands court was placed before by the practicing company secretary appearing on the behalf of foreign court appointed administrator in the bankruptcy. So they also the Netherlands court took up the matter in the NCLT Mumbai and said that since the IBC is going on in our court, so that we should also be made the party of the proceeding, or the proceeding has to be stayed. So the issue was whether the order passed by the foreign court for insolvency can be given effect in India, or whether the CIRP of the CD can be admitted in India in the light of order passed by Netherlands court. So this was the decision. So at that time, the NCLT examined the relevant section of the IBC and said that the rationale put forward is that point number 3 of the decision, section 234 and 235 of the code on recognition of the order of foreign jurisdiction set out the requirement for the government of India to enter into reciprocal agreement with the foreign countries. However, the court found that no mutual agreement has been reached with the Dutch authorities in this case. So therefore, we as the AA are not empowered to entertain the order passed by the foreign jurisdiction in this case. The court finds that as per the section 234 and the 235, the power has been given to the central government to enter the reciprocal agreement with the countries. So there is no agreement exists. So the NCLT does not have any power related to these matters. So those appeal has been rejected by the NCLT. Bharti Defense, it is also the NCLT case. Basically, this is the Bharti Defense and Infrastructure Limited was a steel manufacturing plant in Odisha, was having. The respondent is a power company. The government authority or the power supplying company did no company for supplying electricity. The respondent company disconnected the applicant electricity connection. So the electricity connection of the corporate debtor has been disconnected during the CIRP. So what an enclave order, and so enclave order directed to restore the said electricity connection. NCLT directed to restore the electricity connection. But they did not restore the electricity connection. They said that they has to apply for the new connection, and the security deposit has been given, and there was some old outstanding that has to be paid. So NCLT said that since your outstanding are the part of the resolution plan, so your outstanding will be paid according to the resolution plan, and you have to restore the electricity connection. If there is any earlier securities there of electricity, you can adjust that security amount against your dues, that security deposit amount against your dues. Bhatia Coke Limited versus in the matter of Bhatia Coke Limited NCLT case, SBI was the applicant in the case of in this case. SBI was the one of the COC member which has the 32% voting share in the COC. So COC the resolution plan was approved by the COC with 100% voting share. So even SBI has voted in favor of the resolution plan, but after the approval of the resolution plan, he applied to the NCLT that RP has not conducted, RP has made some procedural irregularity in the process. He did not convene the COC meeting in the proper way. There was a proposal by the erstwhile promoter for the settlement, which was also not taken care by the RP. So this was the matter which has been raised by the SBI. So the NCLT has has given the verdict in the favor of the RP. He said that since you are the part of the COC, you have voted in favor of the plan. So after the approval of the plan, there is no question can be raised. And also the respondent, the RP state that if the SBI also said that since they have been because they have voted in favor of the resolution plan because there was a town foundation and they have under protest or under pressure they have voted in favor of the resolution plan. So the counter was by the RP is that the time is limited in the IBC and the COC wisdom has to be prevailed. All the COC member voted in favor of the resolution plan and same was approved by the 100% voting. Applicant also voted in favor of the resolution plan. So there is no provision and there is no provision under IBC for the applicant to vote under protest. And moreover, the IBC is a time bound and there have to be a commercial wisdom of the COC member before exercising on voting. And the respondent or the RP further state that voting share of the applicant is only 32%. Even assuming that the applicant has voted against the resolution plan, still the plan would have been approved by the 68%, which is higher than the minimum approval being the 66% of as per the IBC provision. In the matter of Bharti Defense, what happened in this case? In case of Bharti Defense, the resolution applicant was the asset reconstruction company. So asset reconstruction company has to take the prior approval to submit the resolution plan, to take the prior approval from the RBI to apply as a resolution applicant. The ARC is eligible to submit a resolution plan without prior approval of the RBI regulator under the provision of the IBC. This was the issue because the ARC has not taken any prior approval of the RBI. So what was the decision of the NCLT? The NCLT rejected the resolution plan. Resolution plan is a conditional one subject to the approval of RBI. Recommended IBBI to investigate into the matter against the resolution professional and the management to look into the act of their member in the COC to favor one resolution applicant because that ARC has not taken any approval. So they have rejected the resolution plan. NCLT has rejected the resolution plan and recommended the IBBI to investigate the matter because the RP NCLT was the view that RP and the management COC has taken the favor of the ARC. So these are the case laws which are pending, which we have discussed now. So today we have discussed the MCQs and the pending case laws.